with the issues of virtual court proceedings, I have the views of another senior advocate of Nigeria, Ahmed Raji. Mr. Raji has about 30 years' experience in administrative and constitutional matters, criminal law, telecoms law, arbitration, and other areas of legal practice. He's also widely respected for his keen attention to details. In this interview, he calls for caution with the use of virtual proceedings, especially because it believes that there are weighty issues of a low-tech environment and challenges of power supply, amongst other issues.
I believe we have to be very cautious in the sense that, one, do we have enough technology in this country? Is our technology well developed to accommodate such? And two, the power supply. I think these are basic fundamentals that must have to be addressed before we can key into such a novel idea. It is not a bad idea, but we have to ensure that we have the necessary materials so that we won't run away from one problem and enter a bigger one. A small one, then enter into a bigger problem. But quite apart from this, what about trial courts? What happens in the trial courts? Yes, there is front-loading, but in the course of the hearing, there may be such huge documents that you may need to tender fiscally. So what happens? For motions, yes. But for trials proper, how do we do it? And then in criminal trials, where will the accused be? In his house? In his lawyer's chambers? Or in the prosecution's office? Or he will go to the judge's chambers to be with the judge?
Or the correctional center?
Or he will remain at the correctional center if he's not on bail? Where will he be? So these are the issues. I think it calls for a lot of fine-tuning, and I will greatly plead or recommend that we embark on a cautious approach to it. Perhaps for now, maybe limited to motions. And even for that to be effective, the necessary wherewithal must be provided in the courts. And conscious efforts must be made to ensure, and not just only government, I mean the private sector, that the power issue is resolved in this country. If I'm a lawyer in a remote area, which I'm entitled to be, and there is no network in my place, what happens? Does that mean I cannot join in full hearing? Then what happens to the right of my clients? So for any society or for any court system to want to embark on such a scheme, the government must make sure that everybody interested in using the facility is enabled. Otherwise, it will be a breach of fair hearing, or it may amount to a breach of fair hearing. Let me not conclude. So let us start from the basics. So that it's commendable. We started by the motions only, and maybe the appellate courts, which is the lawyers' courts, so to speak. But for now, the trial court must have to be very cautious in adopting it, because a whole lot of issues, for example, the criminal trial I've just mentioned, it may require an amendment to the law, which requires an accused person to be present whenever his trial is on. And in this case, where will he be present?
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Shieli. Thank you for watching.